Good afternoon, everybody. Thank you very much for joining us for our webinar. So today we're going to have a look at the data protection issues which arise from redundancy. Unfortunately, one of the sad side effects of the pandemic is that a lot of businesses are struggling with redundancy programs, and so we're seeing quite a lot of questions which arise relating to specifically the data protection side of redundancy. So we thought we'd have a look at that today. Now, I'm aware that a number of people have already submitted questions in relation to the more sort of redundancy side of things rather than the data protection side of redundancy. And so we've obviously captured your details and the question, and Padma, who is our redundancy expert from our employment team, will come back to you. And again, if anyone has got any redundancy specific questions rather than looking at the more data protection side of things that we'll be looking at today, then please do submit questions via the question and answer box and leave your details so that we're able to get back to you. That reminds me that if you do have questions, if you could use the question and answer facility rather than the chat box, that would be fantastic. And also there is a feedback form that will be available on the Q&A, and it'd be really helpful if you could spare a few minutes to fill that in for us. So in terms of today, who's speaking, as you'll see from the slide, I'm Joanne Bone. I'm a partner specialising in data protection issues. I've been a data protection lawyer for over 20 years, and GDPR is the third data protection regime I've had to grapple with. Lauren Burrows is also a data protection lawyer. She's an associate in my team, and Padma is our employment specialist, and she's a senior associate in the employment team. So we are your speakers for today. So I'm going to hand over to Padma in the first instance, because Padma's going to give us an overview of what the redundancy process looks like, and then what we'll do is we'll pick off specific issues that we are seeing on a day-to-day basis in practice, answering questions which arise. The final thing we'll look at, which we'll spend a little bit of time on, is how to handle a subject access request in the context of redundancy, because again we are seeing a lot of subject access requests being made, and we'll talk about that in detail when we get to it. So I'm going to hand over to Padma now, who's going to give a brief overview of what the redundancy process looks like. Thanks, Padma.
As Joanne says, I'm just going to quickly run through in a summary format of the steps that you would expect to see in a redundancy situation, and then we'll pick off from some of these steps of the common data protection issues that we are seeing at the moment. So first of all, as you know, it'll be a case of identifying that there may be a redundancy position and notifying staff that you are proposing those redundancies. If you are proposing to dismiss 20 or more within a 90-day period, there are some additional layers, as well as if you are a trade union recognised organisation, or you already have collective agreements in place in your organisation saying that regardless of numbers that you will always collectively consult. You will also then be looking at electing representatives through which you can feed information through about the proposals and the steps that you're going to follow. Again, going back to if you've got trade union agreements, collective agreements, or you're looking at proposing to dismiss 20 or more people within a 90-day period, there's a whole collective consultation process using the elected representatives through which that information is passed. And then we'll have individual consultation once we get through those initial steps. And during that individual consultation period, you'll be looking at things like, is it right that we are proposing that X, Y, and Z roles should be at risk of redundancy? What can we do to mitigate against that redundancy situation? And that may include thinking of if other alternatives, such as alternative roles, changes to pay, job structures, hours, and so on. And then ultimately, you might get to a dismissal and appeal stage. So moving on to the next slide, one thing that we are seeing as part of a collective consultation process is, as I said, electing representatives. And when representatives are elected, you would usually identify people into groups of affected roles. So you may decide that you've got a sales workforce, a production team, and then a marketing team, for example. And you want to look at making some changes within each of those specific groups. As part of a collective consultation process, what you may go and do is then say, right, can each group select one representative through which we will, in the immediate future, pass on all the information, which they will then cascade down to you. And you do that because that tends to be an easier, more expedient way of passing on that information rather than individually passing on information to, say, 20, 30 or even hundreds of people in some of the cases that we're seeing at the moment. So that's what the role of a representative would be. It would be to consult on behalf of the group that they represent and pass on and cascade that information down to that group. Now, in order for them to effectively start consulting, asking questions of the employer, and also to be elected, they will need to know about the people that they are representing and also how to deal with that. And traditionally, pre-GDPR, what you would tend to find is that employers would freely put out a communication to say, right, we are looking at 10 redundancies in the sales department, we're proposing another 10 in marketing, maybe 2 in HR and 3 in finance, for example. And one thing that I think has come to light at the moment in doing some of these, and this is where I'd be interested in your view, Joanne, is that actually by providing some of the information, there's an argument, isn't there, that we're providing people's personal data. So, for example, if you're saying we want a representative to represent finance, HR, and another team, and actually you already know that there's only one person in HR, there's an argument that that person is already identified and we're giving that information to a representative without potentially their permission. Do you want to talk us through, Joanne, as to what your guidance would be of how much information we pass on to a representative?
Yeah, I think it's an interesting issue, Padma, because I think it's been magnified as well by COVID, because my understanding is, and correct me if I'm wrong, Padma, that quite often representative meetings were held in person in terms of somebody would show up and talk to people, but obviously a lot of things have to be done virtually now, so there's a lot more personal data we're talking about in terms of contact details and things like that which are at issue. So I think there's two things which need thinking about, and the first one that Padma's raised is quite often people forget that personal data is not only specifically naming somebody, so me naming Padma, for example, but also if there is only one person in a role, naming that role means that that person is identifiable, so that is still personal data. So you can't get around the rules relating to GDPR by saying, oh, our accounts clerk, if there is only one accounts clerk, because that will obviously identify somebody. I think the other thing to bear in mind, and this is what we've seen an issue with recently, is data minimisation, in that quite often people do forget that they are always meant to have a look at any data that is being used to see whether or not it's adequate. Is there too much data that's potentially being shared? So, for example, as Padma was saying, in terms of we have a number of clients who are talking to us about the need for representatives. And certainly one suggestion was that what a client was proposing was sending to everybody at risk of redundancy the details within their group or department, everybody else that was at risk of redundancy, and saying, well, this is everybody in your team that's subject to redundancy, pick somebody amongst yourselves as to, or nominate somebody from that would be a good representative. Now, I certainly don't think that is a good way to do it, because I think it's excessive to tell at that stage the representative or the other people within the group, everybody else that's subject to redundancy. So our suggestion in relation to that is that when the individuals are communicated with to say you are at risk of redundancy, they are then also asked whether or not they would be willing to act as a representative. And if they are willing to act as a representative, they're also told that please don't stand for that role if you're not willing to have your contact details shared, because obviously to be an effective representative, you've got to be able to people have got to be able to communicate with you. So I think that's one aspect of it, my advice is definitely don't tell everybody that's at risk of redundancy, everybody else that's at risk of redundancy, and then say who wants to be a representative. I think the other side of it is once you have a representative, as to whether or not you can give the contact details of everybody to the representative for them to properly communicate. And I think this is slightly trickier, and we've spent some time sort of discussing this, and obviously there's sometimes people don't particularly want to engage with a representative, so if there'd been an actual meeting at work, for example, they may not have shown up. So I think the better way to do it, if at all possible, is that essentially the business communicates with everyone that's at risk of redundancy to say, for example, Joe Blogs is the representative, these are their contact details, you know, please get in touch with them or let them know if you are happy to be kept up to date with what is happening. I'm not saying you definitely can't share everyone else's contact details. I think it's just something that does need a little bit of careful thought there in case some people aren't keen on engaging. So I think COVID certainly, in like so many areas, is throwing up new things that need to be thought about in terms of processes, and certainly the representative process is something that we have seen on a number of occasions where issues have arisen that we haven't really had to grapple with before because of the virtual nature of representative meetings.
I agree with you there, Joanne. So I think in terms of what you were saying, just to echo about how much information you give, I agree that I've had clients that have basically said, can we just issue out this communication across the whole business and say these are the teams that are affected and these are the numbers. And I think what you're saying, and certainly what we've been doing together on matters that we've been working on, is, like you say, breaking it down by department and then just giving the information that that team needs to know of, look, your team is at risk of redundancy and we're looking at these number of people, so select a representative amongst yourself. So arguably you're not telling finance, for example, that there's also redundancies in HR, and you're not telling HR that there's redundancies in sales as well, because at this moment in time it doesn't make a difference to their particular pot. So that's where you're looking at in terms of data minimisation, aren't you, really? And the other thing that I've seen, Joanne, is where if representatives want to come forward and suggesting to them that we could set up like a separate email or contact details for them that's different to their personal accounts, because I know that was a worry for one of my clients, or someone that had been come forward as a representative to say, well, look, I don't want something that then gets potentially lost in amongst day-to-day work emails, but I'm also not keen to give them a personal email address, in which case we just help them set up a separate one that wasn't linked to work, so they didn't feel that, you know, someone was tapping in from a company perspective and people couldn't confidentially speak to their representative, but equally they weren't giving out personal details. And I think the final thing that I'd mention as well in relation to this is when representatives are being elected, the other thing that COVID has probably thrown up is normally you'd have some sort of paper ballot or something in person where people could go off and cast a vote. And the other difficulty that we've sort of seen is the need for people being able to post secret balloting, but how they do that and who they do that through. And so we've obviously explored a number of different options and online balloting forums and things like that. So I think anyone that's watching and that's an organisation, just really carefully think about, if you're going to elect representatives, of what platform you're going to use, because there is an obligation to make sure it's done in secret and it's fair, but also something that's accessible to everyone as well. And so there could be some work to do around that before you, and something to put in your planning stage before you go off and kickstart those redundancies. So shall we move on to the next slide? Once we've got through electing representatives if they're needed, and we've sort of whittled down who's at risk, what's going on, and sometimes unless an individual is in a standalone role, so what I mean by that is they're the only person that does that role, it's not interchangeable with another colleague or anything of that nature. And if they're not in that position, but you have, say, a team of 6 people in one team, and you need to reduce that down to only 4 people, what would usually happen is a company would put all 6 people at risk of redundancy, apply a selection criteria, and then select out of those the top 4 people who during that consultation process would then be deemed as safe, and you then carry on consulting with the 2 lower scorers, i.e. being the ones where you're looking at proposing to make redundant. And typically one issue that we tend to see is those lower scorers then having an issue with the scores that they received. So it'll be a case of, I don't understand why I've only scored 3 when clearly I must be much better than X, who I don't think is classed as one of the bottom 2. And you often get asked, well, I want to see the scores that you've given to the other person because I think you're bullying me here or there's a discrimination issue at play. From an employment perspective, we don't see a need for you to give that per se. There's nothing at law requiring you to give that information of other people's scores. Yes, you would provide the individual their own scores because naturally you would need to do that for them to be able to say, well, look, I think you've incorrectly scored me here because you don't seem to have taken into account X, Y, and Z qualifications. So by all means, and I would be recommending that you should provide them with their own scores, but scores of other employees, and I'll come on to Joanne or Lauren if you want to sort of tell me what your views are from a data protection point of view. But from my perspective, there's nothing in employment law specifically requiring you to give other employees details of other people's scores. The time that you might give the information is where you have issues of discrimination, or clearly you need it to demonstrate that you haven't behaved in an unfair manner because it is in that tricky balance situation. Then to be able to defend your position, whether it be pre-tribunal or even at tribunal stage, that is where you may decide to give that information. But when you do, and again, I'm sure something that Joanne will come to talk about, is you need to think about how much information you're giving, such as, are you giving it with the individual's details, or is there some way of anonymising that a bit more? But Joanne, from a data protection point of view, what would you do if someone said, I need to see other people's scores? Or if I came to you and said, well, look, the best way of my client being able to defend that allegation of bias or discrimination is just to give everyone else's scores, what would you do?
It's an interesting question, Padma, and it is something that we're seeing at the moment in terms of, say, under subject access requests, for example, we will see and they'll want to know how they compare with other people. I think the difficulty with it is, as you say, is that if they want to see their score in isolation, so whatever they've got, that may well be fine. But if they also want to understand what other people's scores are, or they want to understand what their ranking is, that causes problems, because obviously that will inevitably disclose third-party data. And one of the things that you are not supposed to do from a data protection point of view in answering a subject access request or in answering a question that somebody's raised is disclose what the position is with other people in the main. And we will have a look at this issue a little bit more when we look at the subject access request section. But it's actually very relevant, and not just in an employment situation, because certainly with what's happened with the GCSEs and the A-levels, rankings and scorings and things like that have obviously been used to determine people's grades. And one of the things that the ICO said is that students actually, rather than parents, but obviously indirectly parents, could request details of the ranking and scoring, and therefore they commented specifically on scoring and rankings in the context of that. And I think you can therefore take that and apply that in the context of redundancy scoring and rankings. And what they said is you do need to be careful. It's easier in some ways if somebody comes top to say you came top, because then you're not necessarily disclosing to other people where other people sit in relation to you. And I think you probably could also say, well, you came sort of middle-ish or something like that. What you definitely shouldn't be doing is sort of indicating to people, well, out of 5, you came at 3 and so and so and so and so came above you and 2 people came below you and their details. So you do need to be quite careful in relation to that. And people that try and push you into providing it, I think you need to explain that that's not something that you're able to provide. So it is something that certainly is. We are seeing that people are requesting, and it does need some thought. But as I say, I think own scores, fair enough. Other people's scores, no. Rankings, it sort of depends what you're revealing by revealing the rankings, and I think it just needs thinking through when you get the question.
Yeah, I agree, Joanne, and I think I guess what would you do? Because obviously one way around this that I sort of mentioned, or what we tend to do, is it's a bit easier, isn't it, when you've got, say, a team of 5 or 6 that you're scoring, because it's a bit harder to identify if you were to take off names and just do scores, and there's other things that you can't really identify, and they're all pretty much of a muchness. It's a bit more easier to provide those anonymised scores to say, well, look, clearly you can see that you were clearly the lowest of scoring 20 compared to the next highest person being at 43 or whatever it is. What would you say if we were in a situation where we're in a tribunal and there's only 2 people in the pool, male, female, and the female, for example, says, I think you've scored the other person higher because they're a male. I'm alleging sex discrimination, and the only way that we can, I guess, show that there hasn't been any element of discrimination is in a tribunal. My client would want to sort of reveal the information of what they've scored the other person to say, well, no, it's because they had X, Y, and Z qualification, they could demonstrate this, this, and this. So it's quite clearly identifiable. Would you then, at that stage, say that we would balance out the different things that we're trying to achieve, and at that point make an assessment, or do you have any other guidance?
Yeah, I think it's an interesting point, Padma, and it is certainly something that we're going to think about in the sort of when we talk about the details. The position in relation to third-party data and revealing third-party data is you shouldn't really reveal it without consent unless it's reasonable to do so. And it may well be in that situation your argument would be it's reasonable to do so without sort of seeking consent. And there's all sorts of things you think about in terms of, is it information that is confidential? Is it something that somebody's going to be bothered about? How is it going to be used and stuff like that? And so if you are comfortable that it's only going to be used in a very limited situation, which isn't prejudicial, that it's limited personal data, things like that, then you may be able to come to the decision that you think it's reasonable to disclose that personal information without seeking the consent of the person concerned. And as you say, if it's necessary to demonstrate that there's not been a discrimination issue, then you may feel that that's something that you can do. The one thing I would say, and I'll say it later as well, but if I forget, is that whatever decision you make about doing that, you need to write it down, you need to write your reasoning down, because you need to be able to demonstrate, if there is a complaint to the ICO, that you did think about the things, you did think about the third party issue, and that you came to a conclusion on reasonable grounds, because that will help you in terms of if there is a complaint, because the ICO will take that into consideration. I think the other thing that I was going to raise at this point as well, Padma, is we've had a question about it, is when we've had all of this information that's been collected as part of the redundancy process, how long should it be kept for? Now, certainly, from a data protection point of view, there's a very broad statement that says that you should keep personal data for as long as is reasonable in all the circumstances, which obviously doesn't therefore give you specific guidelines as to exactly how long you should keep it. I think from a redundancy point of view, you want to be thinking about, well, how long might there be a claim relating to the redundancy process? So from your point of view, Padma, how long do you think would be reasonable to make sure that you weren't facing a claim, or that you could properly defend a claim if you were to receive a claim?
Yeah, I think that's interesting, John. I would typically say around 9 to 12 months, which may seem like a long time. So for unfair dismissal claims, usually individuals need to bring them within a 3-month time limit. There are limited powers by a tribunal to extend that time limit, but usually it's a 3-month cut-off. For statutory redundancy pay, if there's claims that hasn't been calculated properly, then that's actually individuals have 6 months to bring that claim. So typically I would say by 9 months you will know whether there's a claim or not, and if not, there would be an issue of that claim being out of time. I think at the moment I would probably err on the side of caution and maybe even push that boundary to about a year, purely because employment tribunals are so overloaded at the moment that I was in tribunal a couple of weeks ago, and to list a claim that was already in the tribunal system, we're looking at late 2021, and in some cases in London area, for example, we're going into 2022. So that shows of claims that are already in the system, that for new ones coming through, it's going to take a lot longer for us to realise that they're there in the first place, and for them to then be seen through. So I think by a year you would at least know whether a claim is coming or not, and therefore whether you can get rid of it, or if you then by that point know there's a claim, naturally you will keep hold of it for the length of that tribunal period. And I think it's also probably timely to mention that in relation to redundancy, that would be my guidance for information relating to any employee placed on furlough, because we're seeing obviously quite a close link to people being on furlough and redundancy situations. Furlough documents, so letters agreeing that the individual has agreed to go on furlough, what the changes of terms and conditions are during that furlough period. So a lot of employers went down to only paying the minimum of what they recovered from the government and so on. That sort of document, the HMRC has clearly stated that must be kept by an employer for up to 5 years after furlough has ended. So just to bear that in mind, I think. But I think probably what's coming out of this slide and what we're discussing, Joanne, is I don't think there's an easy sort of tick box answer for any of this. It's all going to be very fact specific, and I think you're going to have to look at the different circumstances, aren't you, in terms of when you give the information, how long you keep it for, whether you know it's going to be contentious or not, and like you say, whether it's possible to provide anonymised details, or whether there's ways of and means and provide that information of actually it might not be appropriate to provide it during the consultation period, but actually if you are facing litigation at that point, you clearly probably it does outweigh the balance to then start revealing that information. Or do you provide that information in a way where they can come in somewhere securely, review the information, satisfy themselves, but they're not taking that information away, so at least you're then protecting the information that you're giving. So there's lots of different things that can be done, but it is very fact specific, that you just need to look at the different set of circumstances and the individuals involved and how much information is and isn't being given, I think. Before we move on to the next slide, the other thing that I just wanted to cover off is can tribunals dig into the scores that are given to individuals? Typically, in these situations, even your rationale for redundancy, a tribunal doesn't try and run your business. As lawyers, we don't know your business as well as you do, and so unless that decision is perverse in some way or discriminatory, a tribunal will take that decision at face value as long as it appears rational in some way. So we've had a lot of questions come through to sort of say, well, people are coming forward to say, we can see you've made a profit in this area of the business, or actually things haven't slowed down here, so how can you justify making redundancies? Well, you don't have to be showing a loss on your balance sheets to look at redundancies. It's all about, that typically tends to be the reason, but it can just be simple things such as efficiency of actually, because of automated systems or X, Y, and Z, even if we're not making a loss, it just financially makes sense that we are making cuts in these areas. That can be a rationale in itself. And the same with the scores. A tribunal expects you to understand and know what employees you need and what skills you need. So again, they won't dig into those scores unless there is something clearly perverse or discrimination is being alleged, to the extent that actually the only way that a tribunal can make that determination is looking at the scores and the rationale behind the scoring that you've given. So I just thought that was worth mentioning there. If we can then just move on to the next slide. The other thing that we've had a lot of is sort of holding consultation meetings. And as Joanne mentioned, with COVID, we're seeing different ways of running consultation processes. Consultation meeting, in a nutshell, is something that you're expected to have with affected individuals, which is a two-way dialogue to allow the individual to understand the rationale as to why you're proposing a redundancy, give suggestions on ways to avoid that proposed redundancy situation, and explore other things, whether it be saving their current job as it is, or looking at adaptations, as I say, reduction of hours, job sharing, those types of things, or even looking at alternative roles. And so what you tend to find is, for a fair process, as a minimum, you're probably looking at least 2, 3 or 4 consultation meetings with individuals to discuss the situation. And one thing that I've been asked a lot of is, because these are being held by way of Microsoft Teams, Zoom and things like that, is it's easier for us to capture everything by recording it as an employer. Or on the flip side, I have also had individuals come to me to say, well, do you know what, I had this meeting, I didn't think it was right, so I covertly recorded it. So HR don't know that I was recording them, but this is what I've done. Would you like the recording? What would you guys recommend, Lauren, Joanne, just in terms of recordings? Can we record them? What should employers take into account?
Yeah, so I'll pick this one up for you, Padma. So I think in terms of recording, you need to think about it in the same way that you would with any other capturing of personal data. So firstly, obviously thinking about your reasoning for capturing it, and sometimes I think, because like you mentioned, we're now using Microsoft Teams or we're using kind of other virtual type of video calls, it is easier to just click press record and then sit and not have to write notes. And I know obviously in terms of kind of capturing those meetings, keeping a note and a record of those meetings, I think it's hard to probably justify, because from any type of collecting of personal data, using of personal data, the kind of essence that runs through GDPR and the data protection laws is it should be proportionate and should think of kind of the least burdensome way on people. So essentially, I'd say probably initially think about the reasoning why you want to collect it. Is there a strong reason of why you're recording it? Is it because, say, for instance, reasonable adjustments? I think because it's easier and it kind of saves you writing lots of notes is probably not necessarily going to be on its own a justification. That being said, obviously you're kind of then thrown into what lawful basis that you're going to use. In terms of kind of recordings, you've got to think about what lawful basis can you use for recording that and keeping it. So which largely kind of throws you into the area of consent, which, as you know, for employees, getting consent in the first instance is difficult because of that imbalance of power. And you're not necessarily only going to be thinking about just the person who's having the consultation meeting, so that person at risk, but also everyone else, the other employees, so whether it's a HR manager or someone else or their manager who's in the consultation meetings. And if you're going to be getting consent, what does that then throw you into all of the other things, such as, is it a GDPR compliant consent? How are you going to make sure that those rights are captured? Because obviously, if you're collecting personal data and storing personal data on the basis of consent, when can you then kind of, if someone wants to withdraw their consent, what would you do in those instances? Again, thinking about, you're not just thinking about one person here who's having the person at risk, you've got your other employees that may also be in there. I know one thing we've also spoken about previously as well, Padma, is something that I'm sure everyone's seen with these kind of video calls, is you kind of have people walking in the background, kids running in, someone walking in. So just thinking about what actually other personal data could you be capturing in that recording in the background of that consultation meeting, which obviously all adds into essentially your risk assessment that you should be doing of whether you should be recording. What I tend to say in terms of things like recording, or which kind of fall into stuff like that, is you're capturing kind of an image of people, you're capturing quite, whilst it's not sensitive data, it's quite important for those people at risk, and thinking about whether you should be doing a risk assessment, and which is obviously from a GDPR perspective, that data protection impact assessment of capturing the things about what's our lawful basis for it, our reasoning for doing it, how are we going to store it afterwards? Because if you say, for instance, we're using Teams now, how are we going to store that recording with people's personal data? Have we got the right agreement in place with Teams to allow us to do that? How long is the retention period for that? What happens if after the fact you want to, that the person at risk wants a copy of that? How are you going to disclose it? How are you going to securely disclose it? So it's one of those things that I think it's not necessarily no, you can't do it, but there's a lot more considerations that need to be taken rather than just yeah, we can record it because it's going to be easy and we can for us as a business to keep a record, and we can provide them with a recording. And kind of just the following point in relation to that was in terms of like with any collection and processing of personal data, is how are you making sure you're being transparent about it? So if you are going to start recording, you've done your data protection impact assessment, you've considered how long you're going to keep it, how you store it, how it's being kept secure. Are you going to then have to update your privacy notices as well to make sure? And for something like that, I would probably suggest calling it out in a privacy notice, because obviously keeping a recording of someone is kind of a lot more personal data, and make sure that it's definitely called out how you're dealing with it. For the flip side, on the covert recording by employees, this is a kind of difficult area, and I appreciate difficult for businesses, because whilst there's kind of that acceptance now that employers should not be covert recording, and if they are, it's only very, very limited, and usually just from a criminal perspective. From an employee's perspective, it's difficult. How do you stop employees from covert recording now that everyone has a mobile phone that they can just quickly under the desk click record? Or if you're on a phone call and someone starts to record it in the background, obviously those people in the business who are on the other side of the line aren't aware until after the fact. And I know, Padma, from your perspective, you don't tend to find out until it's coming up to a tribunal or you're midway through a tribunal. What I would say is the area in this is kind of, it's not clear, because in terms of employees themselves, obviously they're not a big business. So the question is to what extent they fall within GDPR. There's been a run of case law which was under the old law, but the wording is similar under GDPR in terms of that kind of household and domestic purpose, and whether that, which is essentially falls outside of scope of the data protection law. And so the case law that has kind of come through over the past kind of 20 years or so essentially says is more that it should be construed narrowly. So whilst I accept it's difficult for employers, it's kind of that grey area that it could be that the employees fall into being kind of falling foul of data protection law, but it is still kind of that grey area. So what we would probably tend to suggest, which I would probably throw back to you, Padma, is terms of what an employer can probably do to kind of capture, to stop people from covert recording, because I think just you need to not necessarily think of just that employee who is covert recording being that employee at risk, but also if it's a HR manager, if it's a manager or another one of your employees, how are you protecting them? How are you protecting kind of the personal data that's being captured about them, and how they might not want that to be captured? So I think I'd throw that one back onto you, Padma, in terms of how would an employer stop an employee covert recording?
Thanks, Lauren. So actually an interesting question, and something that a tribunal actually considered last year or about 18 months ago. So what I would always recommend is in your invite letters, you should set the parameters and boundaries of what's expected. So something that I've been inserting into letters that I've been doing for clients is around how we're going to capture what has happened at that meeting, i.e. we're going to provide a note taker. You can bring your own through a companion if you want, but you must expressly expressly state that we do not want them to be recording that information. The other thing that we saw, as I say, from this tribunal case from 18 months ago, in this particular case, the company had in its disciplinary policies, if you covertly record any meeting, regardless of what it is, without express written consent, we will class that as gross misconduct and take action accordingly. Now, in this tribunal case that I'm talking about, individuals still did it anyway, and company did not know about it until after a dismissal had taken effect. A tribunal case came about by the individual claiming unfair dismissal, and so as part of that, tribunal was there to consider the fairness of the process, etc. And individual then pulls out a recording to say, well, here you go, this is what will support my case to show that it was a prejudged decision. And what the company were then able to do is to say, well, actually, putting aside merits of whether or not we followed a fair dismissal or not in a fair process, tribunal, if you find against us, we still want to argue that this individual should not receive any compensation, because had we known about this recording at the time, we probably would have just dismissed for gross misconduct anyway. And so it allowed the company, successfully in this case, to run an alternative argument to say, well, do you know what, if they weren't dismissed for this, they would have been dismissed anyway for gross misconduct for doing something they shouldn't have. And in that particular case, individual then walked away with no compensation because of that. So 2 points, as I say, disciplinary policies, think about updating those to cover off things like covert recording, and also covering things off in your letters about what is and is not expected at that meeting. One thing to say though, even if you have that in your disciplinary letter or in your invite letter or your disciplinary policy, unfortunately, we can't stop people from still recording that information covertly. And in those types of cases, as I say, you can use it to help with your defence of things, but a tribunal will probably always still allow that in as evidence to consider it if it shows what the individual is saying it shows, because it might still help a tribunal to understand and determine the legalities of that case and whether they pass the legal thresholds to class as discrimination or unfair dismissal. So again, this is where I think anyone that is conducting, whether it be redundancy processes or disciplinaries or grievances, that those managers are either adequately supported through HR functions or are adequately trained themselves if they're not going to have someone within HR sitting with them, of understanding that that is always a risk. And so to be careful about language that's being used and the way they conduct themselves and so on. And just going back onto the flip side, Lauren, of it being easier for the employer to record the information, you know, by just pressing record on Microsoft Teams, etc. One thing that you also ultimately need to remember as well is if we get to a tribunal, tribunal will not sit there and listen to a recording or watch a recording through Microsoft Teams or anything. They will still expect you to draw up a transcript. So you're possibly pushing the work later on down the line of then someone sitting there and still making the notes at that stage. So that's probably another thing just to factor in. And as a final point, as Lauren already pointed out, one set of circumstances where it might be reasonable for you to consider recordings would be as a reasonable adjustment, where someone has a disability or some form of difficulty of being able to take notes themselves, or you know, reading and writing notes, in which case if you are going to enter into that territory, just be careful of all the points that Lauren's just said. So think about how you can facilitate that recording in the safest way possible. So is it that you say, yes, we can record it, but can we do it where you come into one of our locations and you're in a room so we know that no one else is walking in and out, and sort of perhaps put some parameters or boundaries around it. So going on to the next slide then, I think this is back over to the data protection guys. So one thing that I'm certainly seeing a lot of, and we've seen sort of a steady increase in my view, as tribunal claims increase, and obviously we are already again or starting to see an increase of those claims coming through. One good way of an individual to work out whether they've got a claim, what the merits are, and also another way of getting disclosure, and can be quite a sneaky way of getting disclosure as well. So when there's a tribunal claim, a court will order individuals to disclose relevant documents to the case. And I've had situations where individual waits for that to happen, but then separately puts in a subject access request as well, which the tribunal side of it is dealt with by HR, for example. The data protection of it is dealt with IT and some other specific data protection department. The two don't talk, and then suddenly there's additional documents being disclosed by the data protection team that haven't been disclosed by HR. And suddenly it then creates a credibility trust issue of individuals saying, do you know what? They haven't complied with the tribunal's orders properly because I've suddenly managed to get hold of X, Y, and Z. So do you guys just want to talk us through sort of DSAR requests, who can make them, given that we are seeing a lot of it through tribunal processes? Oh, Joanne, I think you're on mute. You've done a me.
Sorry, technology has defeated me. I was trying to be really quiet while you were talking. I think you're right, Padma. I think we are seeing subject access requests an awful lot more than we ever did. They certainly did used to happen under the old law, but since GDPR came in, they're a lot more prevalent. And I think one of the reasons is because certainly in the employment context, employment lawyers do use them to try and get information. So we do see them quite a bit. I think there are some misconceptions around subject access requests, and we don't have a huge amount of time, so we're going to have a quick canter through. We are going to be doing a session which looks in detail at a subject access requests in terms of running it from start to finish and the process, but this is just a quick canter through in the context of employment issues. I think the thing to bear in mind is a subject access request is a request made by the individual for personal data about them. And certainly sometimes what we see is that employment lawyers on the other side will frame a subject access request to try and get more information than that. And I think we should be very careful about that. So, for example, we sometimes see a subject access request in terms of I want all personal data about Joe Bloggs, and I'd also like all details of any minutes surrounding the redundancy process, which may not relate to Joe Bloggs at all. And certainly those minutes are not something that is disclosable subject to a subject in response to a subject access request, unless they are the personal data of the person concerned. So I think that's one thing I would say that you do need to be careful of if you receive one, that you don't actually disclose everything prior to the point of disclosure in an employment tribunal. You just disclose that you've got to disclose under the data protection legislation. The other thing that I would say is that we do see solicitors, as I say, make a lot of requests. If you do get a request from a solicitor that's acting for somebody, then you do need to verify their authority. So there's nothing wrong with going back to them to say, please can we see a written confirmation from your client that you're authorised to act, although sometimes solicitors do send that at the same time they make a request. Interestingly, we do also see subject access requests being made by employees' parents or husband or people like that. And again, just because they're a family member doesn't entitle them to the personal data of the employee that's bringing the making the request. You do have to verify authority in those situations. In an employment situation, if you get a subject access request, I'm assuming that unless it's a really, really big business, you will probably know the individual that is making the request. So verifying identity isn't as important as it would be if, for example, you were to receive a subject access request from a customer who you have no idea who they are. If, however, you are in a big business and you are not sure whether the person making the request is the person who the data is about, then you are required to verify their identity. And by verifying their identity, it's got to be proportionate in terms of double checking things that are proportionate. What you can't say is, please send me a copy of your passport, your driver's license, 3 utility bills, etc. That would be disproportionate in relation to verifying identity. So once you've essentially worked out who's making the request, what it is they're wanting, and if somebody's made it on their behalf, are they authorised to do it, you have to think about what the nature of the request is. Certainly, we see lots of different sorts of requests. Sometimes a subject access request is please provide the following emails, or please provide emails between the following people. So they're quite specific. Sometimes they'll have a date range around them. Equally, we do see subject access requests that say, please provide all personal data that you hold about me. Now that can be particularly challenging in the case of employees, because if you've got an employee that may have been employed for 16 years or even longer than that, there'll be an awful lot of personal data that will be held by the business about them. So we're quite often asked, if we get a request like that, what do we do about it? Can we ask them to narrow the request, for example? And certainly you can ask for people to narrow requests. You could ask whether they're looking for specific things. They're not required to actually do it. If you say to them, please will you give us more information about what you're looking for, if they choose not to, you can't force them to do that. What also we do see as a common misconception is that if somebody does ask the person making the request for them to narrow the request, they think that time stops. Time does not stop. So we'll look at time periods in a minute, but essentially you've got a calendar month to respond, subject to it being a complex request, which gives you longer. It will not stop that calendar month running, so do not stop doing your searches. If you ask somebody to narrow the request and they refuse, then what you have to do is to make a reasonable search. Do the best that you can in order to be able to find the information that they want. But certainly doing nothing or sort of downing tools until they narrow the request is not something the ICO will like. And also the ICO won't be very happy if you say, well, actually, we can't find stuff in terms of our systems don't enable us to find things. They will expect you to have a process and systems to enable you to provide the personal data that people are looking for. So moving on to the next slide, in terms of does it matter why somebody is making a subject access request? In the employment context, sometimes the request is being made because people want to get information early. It's balancing. People want to know whether or not there's a smoking gun that might help them in a claim. Sometimes, and we do see this, people are doing it simply because they're trying to force a settlement. They know that subject access requests are painful. Anybody that's had a subject access request that's in the meeting today will know that they are not easy to respond to, and they do take up an awful lot of time to be able to respond to them properly. So the motive is something that is actually relevant. There are provisions in GDPR itself to say that you can either refuse to respond to the request, or you can charge for responding to the request, where it's manifestly unfounded or it's excessive. Now, obviously, that raises the question in terms of what's meant by manifestly unfounded or excessive. And the ICO has recently expanded their guidance on this. So it's always useful, I would say, if you get a subject access request, to read through the ICO guidance, because they do update it. They don't always make a fanfare about updating it, and it may well be helpful to you to have a quick read through what their current practice is before you make the response. Certainly from a manifestly unfounded point of view, there are a couple of things that are quite useful. If somebody makes it very clear, for example, that I am making a subject access request, but if you pay me £20,000 in settlement of my claim, then I will withdraw it. The ICO doesn't consider that to be a proper subject access request, because they're not actually interested in finding out what personal data is held about them. What they're interested in is forcing you to pay them some compensation. So that could be regarded as manifestly unfounded. The other side of it is malicious. So if, for example, the individual makes it very clear that what they're doing is they're trying to disrupt the business, or that they have a vendetta against somebody within the business, or that they send the same request every week on a Thursday just to cause disruption, again, there is a potential for arguing that it is manifestly unfounded. Just because you don't like the request, or just because they may use quite aggressive language, however, does not make a request manifestly unfounded. So before you rely on that and refuse to respond, then you do need to check that you're on fairly secure ground with it. The other thing to point out is if you are going to rely on that, you do have to tell somebody that you are not going to respond and the reason why you are not going to respond. Excessive, that sort of looks at, does it essentially, are they making the same request on a repeated basis for the same information? I would say just because somebody may make 2 requests, so they may make a top-up request, doesn't necessarily make it excessive. It's a question of what's reasonable, sort of what do you think might be excessive in terms of if you've made 10 requests once a week, then I suspect you'll be able to at some point say that that is excessive. So I think it's worth thinking about that in terms of the motive behind the request. It is relevant. The other thing that you will need to think about, which is related to that, is whether or not there are any other exemptions which might help you. So moving on to the next slide, GDPR doesn't really set out many exemptions in the text of GDPR itself. Where you find the exemptions that are going to be relevant are in Schedule 2 to the Data Protection Act 2018, and there is a big long list of exemptions. The thing I would say about them, and because of time we don't have a huge amount of time to go through them, is that they are construed very narrowly, and you do have to look at what you're exempt from, because essentially the way they work under Schedule 2 is that it explains which provisions of GDPR you're exempt from, and then it sets out the exemption. So you do have to look at them very carefully. They're not straightforward. We've put a list on the slide of the ones that may be relevant in the context of an employment subject access request. One of the ones that we've talked about already that very commonly crops up if you are looking at personal data from a subject access request point of view is third-party data. And quite often what an employee will want to know is what their colleagues have said about them. Now, as I said earlier, you shouldn't be disclosing information relating to third parties unless it's reasonable to do so. And in thinking whether or not it's reasonable to do so without consent, then you need to have a look at the circumstances surrounding it. So, for example, if somebody has made a statement about the employee and one of them is a colleague and one of them is their line manager, it's probably reasonable to disclose without consent what the line manager has said in an appraisal, for example, because that's something that is reasonable for them to stand behind. If, however, somebody at the same level or below them has made a comment about them, it may well not be appropriate to reveal that without consent. So it is quite a complex area, the third-party data, but it does need thinking about. I'm not going to go into detail about each of these because we just don't have time today, but I would suggest that if you are, when you are faced with a subject access request, is that you do consider the exemptions in terms of whether or not any of them are applicable to the personal data that you are being asked to provide. The other thing I would say in relation to responding to a subject access request that sometimes people forget is that you do also have to provide a long list of information, which is generally information which is in your privacy notice, so do remember to provide that. I'm now going to hand over to Lauren, who's going to finish up on the next 2 slides, which looking at what sort of searches do you have to carry out, I think is the first thing, so handing across to Lauren.
Hi, thanks, Joanne. Yeah, and sorry, apologies. I know there's only 2 minutes, so apologies if I'll try and go kind of through as quickly as possible, but it may go a couple of minutes over the 1/2 mark. I think just one thing I was going to add, Joanne, to the points about the third-party data and redacting is I think a lot of people don't necessarily think about the fact that it's not just a case of redacting names. So just because you redacted, say, a third party's name, they could still be identified because of the circumstances or because of the content of what in the email. So I think if you are redacting, to try and think about all of that as well. Yeah, so in terms of carrying out searches and what you need to think of, your obligations are is to provide, when you receive a SAR, to provide all of the information that you hold as a controller. And I know we've had a few questions pop up in terms of what does that mean and how far do you go, especially thinking about obviously the past 6 months or so, where a lot of these kind of other technologies have been brought up, or chat forums, or use of Microsoft Teams or Slack. So I think when you're searching from a SAR, obviously it depends on what they've requested in the first instance, but it's a search on both emails, anything electronic, anything essentially that falls under the scope of GDPR. So if it's in a paper files that are part of a filing system, your electronic, archived or backup data, anything in different locations. So like I say there, if you have chat forums, if there's any information being shared through WhatsApp, text messages, emails, Word documents, anything like that. So it's basically all systems. So I think at the moment, what I'd probably say before you receive a SAR is think about all of the different systems that you have and where you would actually have to start searching, because that, when, say, for instance, if you then were to receive a SAR at a later point, at least you know where your starting point is, rather than kind of a few weeks having received it, still finding out, oh, actually, we've got this whole other kind of Office 365 storing data that we haven't actually considered. On top of that, because you are controller, there's also the thought of ordinarily you wouldn't necessarily need to ask third parties for the data, apart from there's probably two main instances. If the third party is your processor, so if they're the processor, obviously that's captured. So if you're using an outsourced HR provider, for instance, then you would need to get any information you have on that requester from that HR provider or any other processors. And the other one is in terms of your employees. If you have like a BYOB or they use their personal devices for any work-related purposes, then there is therefore an argument that they are processing on your behalf. So in these instances, obviously, this is then where there can become difficulty, because you obviously then may have to look on someone's personal device, and it's thinking about to what extent that falls within. So the ICO's perspective is really they would expect you to ask those individuals if there's something on their personal device, if there's a reasonable expectation there is. So obviously, I think sometimes you get SARs and it's dependent on who that requester is asking for information on, whether it's their manager, HR, someone else like line manager, someone else, their colleagues in their team, whether there's a reasonable expectation that those people have something on their personal devices in relation to that. So that's one thing that I said would be where I think you should be wary of, because it's not necessarily because it's on a personal device that it doesn't need to be looked at and you can kind of push back on it. It is something that you need to consider and ask others if they're holding anything on that requester on their phones and personal devices. And then if we can just move on to the final slide, just to try and cover that off quickly. In terms of timescales for the response, so your response is a calendar month. One thing that I would say is, in terms of what we've seen, is people come back and make a SAR request and say, I want to receive my response within 7 days or 14 days or by X date. Regardless of that, you have a calendar month. I would say probably that it's probably good practice if you do receive someone who's saying I want a response in 7 days time, to go back to them and say, obviously in line with your obligations under data protection law, you will get back to them within the calendar month, which is the timescale that you are permitted. Obviously, you can extend if for a further 2 months if it's a complex request. The quick point that I would make on that is the threshold for showing it's a complex request is quite high. So just because you think there's going to be a lot of information, or because someone's on holiday, or I've had before because it's Christmas period, or especially say if your kind of office closed down for a certain amount of weeks, that's not necessarily going to reach the threshold of what's complex. So just because it's going to take you a lot of time to search and it's going to bring up a lot of information is not necessarily going to meet that threshold, because the ICO's perspective is that you should have the procedures in place to identify that SAR, deal with that SAR and respond within that timescale. And then just finally, the ICO has released, in terms of, obviously a lot of businesses have been kind of affected quite severely by COVID-19, and it's obviously changed the way that most businesses are doing work. So they had initially issued kind of their guidance that they will be flexible and pragmatic during the crisis, and they've told requesters to be understanding of businesses because there's a lot of other things going on, whether half the staff are furloughed or a lot of the staff are furloughed, or people are working from home, or there's difficulty getting to the office. So it's just a case of thinking about that kind of going forward. What I would say though is obviously as we move more into business as usual, that it's going to probably be harder to show that your delay is caused by COVID, because you would need to show that there is a direct link between you being affected and not being able to respond in time and COVID, and how your business has been put under pressure through COVID during that period you've had that SAR. So yeah, apologies, that was a quick run through those final 2 slides. So apologies to those people who submitted questions and we've not been able to get to your questions due to time. But if you can, those who've obviously left their email addresses and names, and if there's any anonymous ones just popping up now that could leave their name and email addresses, we will try and get back to you and respond to those questions. So just as kind of a final slide, there's the contact details of Padma, Joanne and myself, should anything come up following this webinar. And then we do also have some dedicated kind of COVID web pages on our Irwin Mitchell website, and you can reach the kind of, see there on the slide, some Q&As and for you to submit, and can kind of get some extra help from people from visiting the Irwin Mitchell website. So the final thing for me to say is thank you all for joining. Hope you found it informative. And like I say, we have more webinars coming up, and hopefully you'll be getting some invites in relation to them, and enjoy the rest of your afternoon.